President, Lords, ladies and gentlemen, first of all, thank you so much for inviting me to speak today at this luncheon. I'm really delighted and honoured. And I have to say, it's a really good week in which to be speaking to you because, as some of you may have been aware, we started on the Courts Bill on Monday, and we've been talking a lot about judicial diversity, which I know is an issue of passionate concern to CILEx members and to quite a lot of people here. I was picked out of obscurity to chair the advisory panel on judicial diversity. I've never known quite why. Nobody has ever told me. No. Eagle, stop looking like that because it's absolutely true. No, it was completely out of the blue. And I was asked to chair the panel looking at judicial diversity by the then Lord Chancellor Jack Straw. And I had no choice in who the panel members were. They had already been selected separately. And I really was slightly surprised because although I feel very strongly about these issues and had some quite strong views about diversity in other professions, I had had very little to do with the judiciary. And it was a very, very interesting experience, and I'm absolutely delighted that CILEx is now part of the Judicial Diversity Task Force work. I'm thrilled by CILEx's new apprenticeship scheme. I think all the work that you're doing on social mobility is hugely important in this area. But here I was, in 2009, 6 members of the panel, fantastic people, I have to say. Hazel Genn, whom some of you will know as Dean of the Law School at University College, Andrew Holroyd, who was the immediate past president then of the Law Society, Winston Hunter, a QC on the Northern Circuit, John Goldring, now the senior presiding judge, Nicola Brewer, now Her Majesty's High Commissioner in South Africa, and me. I didn't choose them. They were brilliant. You could not, on any occasion, have put a sheet of paper between the 6 of us. We agreed, and we argued hard. Some of those arguments really were hard, but in the end, we agreed on absolutely everything. There was no minority report. There was no difference of opinion in our conclusions. So what did we say? Well, before I talk about that, I want to pay particular tribute to the Attorney General, Dominic Grieve, who knew I was going to say this. I warned him, and he sadly had to go for even more important matters. And to the Lord Chief Justice, Igor Judge, who's here with us now, both of whom devoted huge amounts of time, I mean hours and hours and hours, to discussing these issues, both with me personally and with the panel more widely, and who, if you like, helped, I think, do what has broadly happened, which is set the tone for a change in conversation, because what this is about is not instant changes. It's actually about a change in the culture. And what I think has been made possible, and I think that Igor and Dominic take a lot of the credit for this, is that the culture is beginning to shift. And if I hadn't believed that before, I certainly believed it on Monday for the second reading of the Courts Bill. I mean, there are lots of other things that everybody was disagreeing with big time. But on the diversity provisions in the new legislation, and that's by no means an answer to everything, but it's a start, on the diversity provisions, there was basically no disagreement. And for that to happen at that stage of the bill suggests that a huge amount of groundwork has been done. And it's been done within the judiciary, more broadly within the legal professions, and with a lot of parliamentarians. And it was enormously impressive, and I'm immensely grateful both to the Lord Chief Justice and to the Attorney General for the work that they have done behind the scenes and in public in this regard. So what was all this about? Well, it was about looking at how we might achieve a more diverse but equally or even higher quality, if that were possible, judiciary compared with the one we've got now by 2020. And we did say that in terms of how you look at these issues, there's no instant fixes. You're not going to do it by next week or even next year. But we did think, with the various recommendations that we made, that by 2020 you could have a considerably more diverse judiciary, including at the most senior levels, and the quality would be as high as it is now. And I think everybody would pay tribute to the very high quality of our judiciary here in the UK. And certainly when travelling abroad, and certainly when talking to very senior judges from other jurisdictions, that's something that is always said. And we did talk a lot to people from the senior members of the judiciary in Canada, senior members of the judiciary in New Zealand, senior judges from Australia. And although they sometimes said, you know, we really didn't have enough women and people from ethnic minorities, and actually I have to say they're not very good on ethnic minorities either. But even though, you know, they would say that in terms, they would say you couldn't criticise us on quality, indeed our quality, and they were often saying it fairly privately, but the quality that we have is enormously high. I think that's very important. So what did we say? Well, first of all, we said that one should be thinking about a judicial career, and that does not mean a career judiciary. But it does mean, for instance, and I very much hope more people from CILEx will take the opportunity, starting off, might be in the tribunals, starting off of what, you know, and we kept on being told by the tribunal judiciary and certainly by Robert Carnworth that people regarded the tribunals as being below the salt. But we've unified the judiciary. And actually we've changed that, and that's really important. And I think, Igor, I think you take a lot of credit for that. Really, really important. So there is one judiciary. And people can start in the tribunals, very part-time, and they can, if they have the skills and the experience, and they do the studying or whatever else it takes, they can move through the judiciary. And that needs to be made easier, and the first of the provisions to make that easier are actually in the present legislation. So that's the first thing. Second thing, part-time working. Now, we debated this backwards and forwards all the time. It is undeniably the case that for many women, and for not a few men, the ability to work part-time as a judge is of paramount importance. We do not mean, you know, job shares, 3 days a week on, 3 days a week off. That might work in some circumstances. It'll be in pretty few. But a lot of women have childcare responsibilities, and that's going to be true particularly at the more junior levels. A lot of men have caring responsibilities for elderly parents, and that is going to become more and more serious. So how could one think about this? Well, one could think about people not perhaps working the full 12 months of the year. Perhaps people work for 9 months. Perhaps people work for 8 months. And this ought to be doable. We did work very closely with some of the magic circles, so-called magic circle firms of solicitors in the City of London. And we did get them to agree to take forward some work looking at how solicitors who retire often in their early 50s might also go straight to the judiciary, but how many of them would not necessarily want to work full time. And we asked them to take that forward. I have to say my one disappointment in all of this is that they didn't take this as far forward as they should have done. The various managing partners who took this on originally have all changed, and I think that's a huge, huge shame. But the part-time working provisions are now there in the legislation, and they were accepted completely in the second reading debate on Monday, and I think that's hugely important. Thirdly, lay chairs for the most senior appointments, so that no one can appoint his or her successor. And I do want to pay tribute to the President of the Supreme Court, Nick Phillips, who absolutely agreed that this was the right way forward, which is in a sense, you go, giving away a pretty large chunk of power himself. And I think that that's a really, really important, and again, those provisions are in the legislation now before Parliament. Fourth, a judicial college, and the beginnings of that have happened, but one of the reasons for that was for people, particularly women, but not only women, who take a career break and would then be able to do, as it were, judgecraft type courses that would allow them to get some of the skills and to actually learn a bit about what it's really like before even applying to become a judge. They would have to do this at their own expense. There's no way I think that the public purse is going to pay for that. But if that's something that a returner decided to do, that's an investment they might well make in exactly the same way as some people go off and do an MBA. And so that is a really important part of, if you like, the broader remit of the Judicial College. And I know that that's a project very, very dear to the Lord Chief Justice's heart. Fifth, outreach. The judiciary itself reaching out to people who might apply. And we think that there hasn't been enough of that. And we think that that's partly because people are frightened of doing it. think there's something really interesting here. When the Judicial Appointments Commission was set up, it was very much, if you like, the view was this is the counter to the tap on the shoulder. The result is that everybody thinks that you can't even encourage somebody to apply. Now, actually, people often need to be encouraged to apply, and particularly people who come from the less conventional groups who might wish to be part of the judiciary but don't have necessarily the confidence or the family connections or whatever it might be. They will need to be encouraged to apply. I think we need to see a lot more tapping on the shoulder, but the tapping on the shoulder is not a shoe-in. The tapping on the shoulder is saying, you ought to go for it. You go for it. And if you're not sure about it, have a look at what the test looks like. Find out about the interview. Do one of the courses that are increasingly being provided to show people what it's like. Go to one of the days that's run by the Judicial Appointments Commissioner. I'm very pleased to see Nigel Reader nodding away. But I think this is really, really important. And I think actually all of you, in your very different roles, could tap people on the shoulder and say, go on, apply, because it's really important that we do see a different judiciary. And it's not because we want to change the quality, but it is because the judiciary, and at the most senior levels I think this is hugely important, needs to be more reflective of the society it serves. And I don't mean representative, but more reflective. It is the point that has been made on many occasions, I have to say, by the one female member of the Supreme Court, Brenda Hale, who has said, she doesn't really want to stick out like a sore tooth. And I think that's right. I think that's an issue, and I think we should, be looking at that. And it's about reflective, not about representative. But I think that means finding people who you think would make good judges and encouraging them to apply. Then appraisal. Well, Igor and I have talked about this endlessly. The government is going to have to find the money. The government notably did not reply to me in the debate last Monday about finding the money, although unofficially they keep saying they're going to find it. But anybody who comes from a less than conventional background, who wants to go into the judiciary, and indeed those already there, including at very senior levels, have said to us in terms that they want appraisal, because they want to know how they're doing and they want to know what they could do to up their game. Now, that is a perfectly normal thing to happen in most areas of life. It just isn't classic if you're a barrister. But actually, it's increasingly common in solicitors' firms. It will be increasingly common for legal executives. It happens in most of society. Interestingly, quite a few of the High Court judges and Appeal Court judges that we spoke to individually were very keen indeed on appraisal. The problem is this. Government can't insist on appraisal. It shouldn't. Appraisal has to be owned and held by the judiciary. It's the judiciary saying, this is ours. We want to help people up their game who are in our midst. We therefore want appraisal, but government will have to find the money. I think I'll have to rest the case there because I don't know quite how this is going to go. But my guess is we are going to see a bit of cash, but not enough for appraisal. But at least that might help because we might be able to make a beginning on some of it. And I do think it's hugely important. Next, the merit criteria of the Judicial Appointments Commission. And we were delighted, my panel was absolutely delighted that our recommendations for changing part of the merit criteria to include public service, and that being something that was actually quite important to see, so that you couldn't just have done the absolutely narrowest, straightest, I've just been at the bar, or I've just been being a solicitor and I've done nothing else, and the only things I've done outside have been sort of bar things or solicitor type things. Actually, you have to know a bit more about wider society. Why is that important? Because it's important for the society that we serve. And I think that seeing that change, we were hugely delighted, as the JAC knows, and that's hugely, hugely good. And last thing, and there's not much more, but a large number of recommendations, but this is the last one I'll talk about, is about giving people the chance of a bit of judicial experience. It is about allowing people to shadow. It's about allowing people to be judges, marshals who are a bit different from the regular brood. It's about opening out the courts to schools, particularly schools in deprived areas. Now, a lot of that is happening. I have to say, some of the judges have been fantastic about this, and this is all done for free on top of a usually very heavy workload. But actually, if we want to encourage a more diverse judiciary, we need to see even more of it. And I suspect that a lot of people here could help with that, because it doesn't only need to be in the courts. It's also about seeing how the legal system works. It could be sitting in an advice centre and seeing what the sort of problems are that people are dealing with. It could be going to look at the advice centres that exist in some of our courts. Those things could be offered and actually are hugely important. So, rather to our surprise, government has listened. Not enough, not everything. The issue about money for appraisal is still a big one, although I do think there are some cheaper ways, less gold-plated ways of doing it, but nevertheless, there has to be some money made available. But they have listened, and some of the provisions we wanted to see are in the Courts Bill before Parliament at the moment. They have, however, put one thing in that I think is a true disgrace, and I'm just going to sound off about it because I'm so cross. And that is against what we felt, although we didn't have a corporate view on this, but more importantly, against what the Constitution Committee of the House of Lords, looking at judicial appointments, had to say. They have put in a provision for the Lord Chancellor to be a member of a selection panel for the most senior judges in the country. I think that is completely impossible. We moved away from the Lord Chancellor appointing judges not very many years ago. We set up the Judicial Appointments Commission because it was seen as important to separate powers. This is a constitutional issue, and I think that the Lord Chancellor is trying to fudge it, and he should know better. And if you have the Lord Chancellor as a member of a panel but not chairing it, how are the other members of the panel going to feel if they vote him down? That's going to be a bit embarrassing, particularly if they should ever want anything from the Lord Chancellor in the future. That's really great. That sounds really kosher to me. I really love the sound of that. So I feel quite strongly that this is completely wrong. But more importantly, the Constitution Committee, which met after us and reported very recently, feels very strongly about this. So you can expect to see a fair number of amendments going against this as the bill goes through the House. And I have to say that Margaret Jay, who chaired the Constitution Committee, was neat acid on the subject on Monday. But I think what's critical about this is that it isn't about legislation alone, or even primarily. It's actually about a culture change. It's about expecting people to start in the tribunals, and I do want to give huge credit to Robert Carnwath. He's done such a lot, and to move up, and to be people from very different backgrounds who are judged purely on their skill. And their skill will be their intellectual merit, but also their skill in handling a court, in being part of the judiciary. And I do think that it's important to realise that being a judge is different from being an advocate. And in fact, I think we have sometimes confused the two. Now, I also have to make a confession. I was, for 6.5 years, chief executive of the King's Fund. And one of the things that was pointed out to me by some of our human resources people there was that after I'd been there for about a year, curiously we seemed to be appointing an awful lot of people who were white, female, middle-aged and very bossy. I can't think why that should be, but of course, the point about that is, of course, that we all appoint in our own image. It's a natural human tendency. And therefore, it is critically important that we guard ourselves against that. That's why the Judicial Appointments Commission is so important. That's why the composition of the panels that it sets up is so important. That's why we moved away from the old tap-on-the-shoulder system. And I think that if I can say freely, that I obviously was doing that, I think when you talk to people privately, they will say, yes, I know X is a good chap. Well, fine, and X probably is an incredibly good chap. But that isn't a reason for appointing people, and I think we have to be very careful. And so what I really want to say here is we need a culture change. We need the provisions in the legislation that are now laid before us. We need money for appraisal, and we need outreach, 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 and that includes all of you. It's not hard, really, to work out what needs to be done. What's hard is to sustain the programme. It means every year benchmarking where we've got to on diversity in the judiciary and looking at where we've got over the period of 12 months. And if it isn't good enough, working out what precise measures are going to be taken across the legal professions, government included but not in the lead, to actually make things better. That is what I call really hard work. It's hard graft, but that's what needs to happen. And so it's a real cross-profession task. I think that CILEx could really help very considerably. I think that CILEx could start running courses for its own members to encourage them to become tribunal judges. I think that'd be a fantastic thing to do, alongside the Law Society that is doing some great work, alongside the Bar Council that's doing some great work. There's plenty that the professions themselves can do. But I think that a lead needs to be set by the professions across the board. And I do actually believe it's possible that by 2020, which is the goal we were aiming for, we will see a much more diverse judiciary of exactly as high a quality as now, or even, dare I say it, higher. Thank you very much.